today we are going to discuss the European Union, and one of the most obvious questions that many people ask is, what is the EU? Is it a state? Is it an organization? Basically, the European Union can be described as a club of nations, a community, or a union of citizens and states. The objective of the club is the functioning of what we call today the internal market. The internal market, previously referred to as the common market, is an area of free circulation of goods, persons, services and capital between the territory of the member states. So instead of having 27 individual member states, each country has its own territory and market. We look at the EU as one whole market where the goods, persons, services and capital move freely. And that is the main function of the European Union. Now obviously by time the EU has evolved and it has become more than just the internal market. It has also included political issues such as citizens' rights or, for example, the concept of European citizenship, which basically gives the individuals rights to travel and rights to protect their own interests vis-à-vis the state. So the four pillars of freedom in the European Union remain goods, persons, services and capital. However, the EU has expanded. The EU is a club. It's not a super state because the member states remain independent states, and it is not a federation like the United States. In other words, Malta or Cyprus are not equivalent to New York or Florida, but Malta and Cyprus are equivalent to the United States. They remain sovereign countries and they can only join the European Union because they are sovereign countries. The European Union is not a colonial empire. Only sovereign states can join, and sovereign states can change their mind and leave. We have seen this through Brexit, where the United Kingdom chose to leave and they left. So when a member state joins the European Union, they remain sovereign states, but they are sharing their sovereignty with the rest. Similarly, when one joins a club, one would give up his choices, his freedoms, to follow the rules of the club. I mean, they do it voluntarily. It's not something which is imposed on them, but there are always opportunity costs to the choices that we make. And when a member state joins the EU, EU law will have to take priority over national law, not because EU law is superior to national law. It is not. In fact, a member state can only join the EU because they have sovereign powers to join the EU, but as long as they are within the club, it is essential to follow the rules of the club, because otherwise the club cannot function and the same member state and the other member state will not be able to enjoy the benefits of the club. The European Court of Justice, in a very landmark case of Vangen and Lewis, decided in 1963, clearly stated that the objective of the treaty at that time was to establish a common market, which, as I said, today it has evolved into the internal market, the functioning of which is direct concern not only to interested parties in the community, but this implies that the treaty is more than an agreement which merely creates mutual obligations between states. So the Court of Justice in Luxembourg is saying that the member states agreed to a treaty, a normal international treaty, but through this treaty they created more than just mutual obligations that you will find between states, because they have given institutions sovereign powers, which these institutions are exercising on behalf of the member states. So, for example, we've mentioned goods. The European Union today has the sole competence, the sole power to deal with goods. The European Union negotiates trade agreements in goods with other member states, and then obviously the member states will be able to enjoy the benefits that the European Commission would have enjoyed on their behalf. This means that the individual member state will not be able to go on his or her own, for the simple reason that the club cannot function. If a member state goes on his or her own, then there is no club at all. So obviously this is a limit of collegiality. Today, there are two main treaties in force, the Treaty of the European Union and the Treaty of the Functioning of the European Union. The former establishes the Union, while the second provides legal framework with which the EU can legislate and create competence in various fields. One can mention for freedoms, yes, but because the internal market includes the further integration of other economic policies, one can mention competences in the field of environment, education, labour law, health, etc., where the club will either have sole competence or it can have shared competence, which means that the powers will be shared between the club and the member states, obviously depending on the subject matter. The main institutions, actually there are 7 institutions according to the treaty. The original 4 are the Council of the European Union, which used to be known as the Council of Ministers, the European Commission, the European Parliament and the European Court of Justice. Then, in 1994, the Court of Auditors, which is not a court, but it is the auditors of the Union, was established. And since the Lisbon Amendments of December 2009, we have 2 more bodies which are recognized as institutions. These are the European Council, where the heads of government meet, and the European Central Bank. The Council of the European Union, the old Council of Ministers, represents the member states, because the member states are one of the pillars, one of the layers of membership of the European Union. The European Commission represents the Union, the community, while the European Parliament represents the people of Europe, who are the second level of governance in the European Union. Then obviously one should not forget the European Court of Justice, or as it is officially known now as the Court of Justice of the European Union, which is there to uphold law. Through EU law, member states will be able to enforce and implement various different European policies. So today, a European law is de facto national law because there has to be a link between the treaties and the national legal order, and through that link, European Union law, whether it's direct regulations or treaty, or whether it is directives that are transposed into national law, will have direct effect, and in the case of regulations and the treaty, direct applicability, which means that an individual can use EU law in front of the national court. Then the individual also have other rights. One can mention briefly, for example, the right in certain circumstances to appear in front of the CJEU, to annul EU law if obviously one satisfies the conditions. Another important criteria is the issue of preliminary reference. This is where the National Court will refer a question of interpretation to the court in Luxembourg, and the Court of Justice will answer to the National Court so that it will enable the National Court interpret EU law. Now this is very important because EU law is the same in all the 27 member states, and it is therefore essential to have the European Court in Luxembourg to interpret EU law on behalf of all the member states. It's not in line with the principle of subsidiarity that EU law or new theories in EU law are interpreted by a national court and then imposed on other national courts. So the relationship between Luxembourg court and the national court is one of cooperation, not one of imposition. Luxembourg is not a Supreme Court, rather Luxembourg is a partner to the national court, and together the national courts will enforce and apply EU law, always with the assistance of Luxembourg should it be needed. Then obviously by time we have the evolution of the free movement of goods, so it involves the common customs tariffs and the abolition of obstacles to trade between the member states. There is the right of free movement of persons, where EU citizens can travel without any legal hindrance to other member states, both for the purposes of tourism, but more important for the purposes of work. There is also the possibility of free movement of services, where one can gain or make use of service in another member state, and above all the free movement of capital, where one can use his or her capital to invest in any business activity anywhere in the territory area. A final benefit for European citizens is the Schengen area. The Schengen area is an area without control at the border, which means that a person can technically walk from Lisbon to Tallinn without having to show his or her passport. Now, this is a very important freedom. It gives us access to all the European Union without any hindrance, but it is a very, very complicated topic and it requires a video in its own right.